He was just 6 years old, and they charged him with murder. In a crowded Kentucky courtroom, the boy sat at the defense table. So small, his feet didn't even touch the floor. He wasn't following the testimony. He wasn't even listening. He was just quietly playing with a toy someone had given him to keep him still. Around him, adults would argue about whether he should spend the rest of his life behind bars. Outside, the courthouse steps were packed with reporters and parents clutching their own children a little tighter. The year was 1929. The Great Depression had begun to tighten its grip on America. In the small mining towns of rural Kentucky, life was hard. Poverty was relentless, and justice was often unforgiving. It was here, in this world of coal dust and hunger, that a 6-year-old boy named Carl Newton Mahan became the youngest person in American history ever put on trial for taking a life. It began as so many tragedies do, with something small, a fight between two children over a piece of scrap metal worth just a few pennies, a moment of anger, a loaded gun within reach, and a decision that would echo through the nation's headlines and courtrooms for years to come. This is the story of the child on trial, of innocence, violence, and the day America was forced to decide whether a 6-year-old could be a murderer. My name's Jack Lawrence. Welcome to Crime at Bedtime. Before we head back to Kentucky, 1929, and the youngest person to ever be tried for murder in America, it's time to take a minute. Time to relax and focus on our breathing. As always, we'll utilize the 4-6-8 method. Breathing in slow and deep through the nose for 4 seconds, filling the lungs, then holding the breath for 6, before breathing out slow and controlled for 8. Here we go. Breathing in for 4. Hold. And slowly and controlled back out. And again, slowly breathing in deep, filling the lungs for 4. Holding. And slowly and controlled back out again. One more time, breathing in deep, slow, through the nose, filling the lungs for 4 seconds. Holding for 6. And slowly and controlled back out again. Now, as you breathe normally, let's head back to 1929 to explore the extraordinary story of Carl Newton Mahan. The year was 1929, and in the coal mining hills of Appalachia, childhood was a luxury few could afford. The town of Cecil, Kentucky wasn't even marked on most maps. A scattering of wooden shacks built around a single dirt road that wound between the mountains. The sound of hammers, mule carts, and the low rumble of mine explosions filled the air. Coal dust settled on everything. The houses, the laundry, even the food people ate. For most families, life revolved around the mines. Men worked 10, sometimes 12 hours underground for a few dollars a week. Women took in washing or tended gardens, hoping to stretch meals just long enough to feed their children. Among them was the Mahan family. They lived in a one-room shack near the edge of town, where the roof leaked and the stove barely warmed the air in winter. Leslie Mahan, Carl's father, was a miner. The kind of man who came home each night with blackened hands and coughing fits that echoed through the thin walls. His wife Mary did what she could to care for their children. They were poor, like everyone else in Cecil, but they were proud. Then there was Carl. Small for his age, thin with pale hair and sharp blue eyes. He was 6 years old, though by the way he spoke and moved, you might have guessed younger. He had never seen a toy store, never gone to a cinema, never worn new shoes. His world was the hills, the dirt roads, and the creek that ran behind the house. For children in the coal towns, life meant learning hard lessons early. They carried buckets, gathered firewood, and, when they could, scavenged for scraps of metal or coal to sell for pennies. This was called scrap hunting. And even at 6, Carl knew the value of an old tin can or a bit of iron. It was a way of survival, not just for him, but for families barely holding on. Violence itself was also never far away. Arguments in mining camps often ended in fists or worse. Guns were tools as common as shovels, used for hunting, protection, and sometimes for settling scores. A child growing up in that world didn't think much about danger. They saw it every day. Carl's father kept an old shotgun in the house, a single-barrel weapon that leaned against the wall near the door. It wasn't locked away. No one in 1929 Kentucky thought much about locking away a gun. A few houses down the road lived 8-year-old Cecil Darnell. He was older, taller and stronger. A boy known for his confidence and quick temper. Cecil came from a family much like the Mayhans, poor, proud, and trying to survive on next to nothing. He and Carl weren't enemies. In fact, they played together most days. Two children bound by circumstance rather than friendship. They spent hours exploring the creek, chasing frogs or searching through rubbish piles for scrap iron. It wasn't play in the way most children know it. It was a sort of work. Small hands trying to bring home something of value. It was Saturday, May 18th of 1929. The morning was warm and heavy, the kind of day when the air clung to your skin. Carl and Cecil set out as usual, wandering beyond the edge of town with a tin pail and a hope of finding metal they could sell to the junk dealer. They came across a piece of scrap iron, half buried near an old shed. It wasn't much, just a rusted strip, maybe worth a few cents. But in a world where pennies mattered, it was enough to start an argument. Cecil grabbed at it first, and Carl protested. They shouted, shoved each other, and then Cecil, older and stronger, hit Carl hard across the face, knocking him down. He took the scrap and walked away. For most children, that would have been the end of it. But not for Carl. Not in a world where strength ruled and humiliation lingered. He got himself up, dusted himself off, and ran home. When Carl burst through the door, his mother was outside hanging laundry. It was said that he went straight to the corner where his father's shotgun stood, the same one used for hunting rabbits in the hills. It was loaded. Carl, only 6 years of age, lifted the weapon. The stock was almost as tall as he was. He carried it back down the dirt path, the barrel dragging slightly through the dust. At the edge of the road, he saw Cecil walking away. Witnesses would later say that there was no shouting, no warning, just the echo of a single blast. Young Cecil Darnell fell instantly, struck by a bullet. When the sound reached the town, people came running. Miners, mothers, neighbours. They found Cecil lying in the dirt, and Carl standing a few feet away, the shotgun beside him. He looked confused, maybe even dazed, staring at the weapon as though he didn't understand what he'd done. By the time the Knott County Sheriff arrived, A small crowd had gathered at the edge of the dirt road. Word spread fast. 2 boys, one dead, one alive, and the sound of a shotgun still ringing in everyone's ears. Carl stood near his fallen friend, clutching the hem of his shirt. The weapon lay on the ground beside him. He didn't appear frightened, and he certainly didn't try to run. When the sheriff bent down and asked what happened, the boy looked up and answered with the plain and honest simplicity of a 6-year-old. "He hit me and took my scrap," he said, "so I got Daddy's gun." Those would be the words repeated in newspapers across the country. Simple, stark, and devastating. The sheriff picked up the shotgun and turned it over in his hands. It was a 12 gauge, nearly as tall as the child who'd fired it. He asked Carl if he knew what guns did. Carl shrugged and said quietly, "They make loud noises." There and then there was no formal arrest at first, not in the way we'd recognise it today. The sheriff simply took Carl by the hand and led him away. He didn't cuff him, he didn't raise his voice. Witnesses just remembered the scene as eerily calm. A lawman leading a barefoot child down the road while neighbours whispered behind them. At the small county jail in Hindman, there were no facilities for 6-year-olds. Carl was placed in the sheriff's office under supervision while deputies took statements. His parents arrived soon after. His mother pale and trembling, his father silent, still covered in mine dust. When the coroner's report came back that evening, it confirmed what everybody already knew. Cecil Darnell had died instantly from a single shotgun blast to the chest. The question wasn't what had happened. It was what to do next. Kentucky law in 1929 was a patchwork of old statutes and inherited English common law. There was no minimum age for criminal prosecution. In theory, anyone, even a child, could be charged with a crime if the court believed they understood the difference between right and wrong. The general standard was age 7. Children under 7 were presumed incapable of criminal intent. Those between 7 and 14 could be prosecuted if a judge decided they knew their actions were wrong. Carl was 6. The law said nothing about what to do with a child his age. The sheriff turned the case over to the county prosecutor, Mr. B.H. Williams, who faced immediate public pressure. Reporters from Louisville and Lexington had already begun arriving, asking questions the law had no answer for. Could a 6-year-old be a murderer? And if so, what should the punishment be? The headlines were blunt. Child slayer, age 6 to face court in Kentucky. Boy killer says he hit me first. Public opinion was divided. Some saw the case as a grim reflection of the poverty and violence of the Appalachian coalfields. Others demanded justice for the Darnell family, arguing that a life had been taken, and that meant the law had to act. Under pressure, Prosecutor Williams made a decision that stunned even his own colleagues. He would charge 6-year-old Carl Newton Mahan with first-degree murder. Not manslaughter, not accidental homicide. Murder, the most serious charge available under Kentucky law. The charge was filed on May 20th of 1929, just a couple of days after the shooting. When reporters asked why, Williams said, "The law makes no exceptions for age in cases of murder. The boy knew what he was doing. The court must decide what justice demands." The case became an instant national sensation. Media across the United States carried the story of the baby killer from Kentucky. Cartoonists drew sketches of a tiny child in an oversized courtroom chair. Editorials debated the limits of justice. In one column, a writer for the New York Times asked, "What is guilt, if not understanding? Can a 6-year-old understand the taking of a life?" Religious leaders also weighed in. Some saw the case as a symptom of moral decay, a sign that America had lost its innocence. Others argued that punishing a child so young was itself an act of cruelty. Meanwhile, the Darnell family was burying their son. 8-year-old Cecil Darnell was laid to rest in a small cemetery overlooking the valley. His parents sat side by side, too numb to speak, as the preacher read from the book of Matthew. Blessed are they that mourn, for they shall be comforted. In their grief, they wanted answers and justice. They didn't hate young Carl, not exactly, but they couldn't accept that their child's death should go unpunished. In their eyes, someone had to be held responsible. And so the prosecutor pushed forward, determined to make an example of the case. Not out of malice, but because the law demanded an outcome. Carl's family had no money for a private attorney, so the court appointed one, W.R. Hall, a local lawyer from Heinemann, to represent him. Hall had never defended a child in a homicide case before, because no one ever had. The trial date was set for September of 1929 at the Knott County Courthouse. In the months that followed, the case became one of the most discussed legal stories in America. Reporters described the defendant as a small boy with clear blue eyes and a mild expression. He was too young to read the papers that called him a murderer, too young to understand what it all meant to be on trial. But when the day came, he would be led into the court wearing his best clothes, a hand-me-down shirt and patched trousers, and placed in a chair built for a man. He'd be given a toy to hold, something to keep his hands busy. And as the adults debated his fate, Carl would sit there quietly, occasionally glancing toward his parents, asking when he could go home. It was a scene that would haunt everyone who witnessed it, because in that moment the line between justice and cruelty blurred completely. The law was about to do something it had never done before. Try a 6-year-old boy for murder. The Knott County Courthouse in Heinemann, Kentucky had seen its fair share of murder trials, but nothing like this. On the morning of September 25th of 1929, people began lining up outside before sunrise. By the time the doors opened, the building was packed. Farmers, miners, reporters, and even travelling ministers who'd come to see for themselves whether justice could truly be done when the accused was just 6 years old. Inside, ceiling fans turned slowly in the humid air. The smell of tobacco and coal dust hung heavy on the wooden benches. At the centre of it all was a small boy, sat with his feet swinging above the floor, a toy clutched in his hands. Carl's father sat behind him, hat in hand, staring straight ahead. His mother wept quietly beside a friend, her hands twisting the hem of her dress. When the judge entered the room, it fell silent. Carl's defense attorney, Mr. Hall, rose to speak. He was a small-town lawyer with a kind face and nervous manner, aware that the eyes of the country were on him. He began simply. Your Honour, this is a tragedy, not a crime. The law was written for men, not for children who do not understand what death means. The prosecutor, B.H. Williams, disagreed. Standing before the jury, he said that age did not erase consequence. This boy may be small, he declared, but he knew what he was doing when he fetched that gun. He aimed it, he pulled the trigger, and he took a life. That is murder. And with that, the trial of a 6-year-old for homicide began. The first witnesses were neighbours who'd seen the two boys that day. They described how Carl and 8-year-old Cecil Darnell had argued over scrap metal, how Cecil had struck Carl, and how the younger boy had run home crying. Then came the account that silenced the room. A neighbour who had seen Carl return moments later, the heavy shotgun dragging behind him. She said she called out, but before she could reach him, she heard the blast. When she arrived, Cecil was already on the ground. The coroner would testify next, describing the wound in measured tones. A single shot from close range. His words made even the seasoned court reporter stop writing for a moment. To prove murder, the prosecution had to show that Carl had formed intent, that he understood what he was doing and what the outcome would be. That was the impossible line the court was being asked to draw. Could a 6-year-old comprehend death? The prosecutor argued yes. Carl had gone home, fetched a gun, returned and fired. Those were deliberate steps, The actions of someone making a choice, not a reflex. The defense countered that a 6-year-old's understanding of cause and effect was barely developed. Kyle, they said, was reacting as a frightened child, not a calculated killer. Attorney Hall asked the jury to look at the boy, to see for themselves the difference between childish anger and adult malice. You have before you a child who can neither spell the word murder nor understand it. Are we to hang guilt upon a mind that does not yet know right from wrong? There were no psychologists called to testify. The field of child development was still very new, if at all, but reporters quoted local doctors and teachers in their coverage. One teacher told a correspondent that her pupils, even at age 8 or 9, often thought of death as something temporary, like going to sleep. Another said flatly, children this young cannot imagine permanence. The newspapers carried headlines that blurred the line between tragedy and spectacle. Baby killer plays with toy as trial begins. Boy of 6 faces jury in murder case. Outside, vendors sold lemonade to the crowds waiting in the heat. Inside, court resumed each day under the slow turning of fans and the weight of disbelief. Throughout the proceedings, Carl remained mostly quiet, sitting beside his lawyer, watching the grown-ups talk, sometimes tracing patterns in the wood grain of the table. When asked if he knew why he was there, he said softly, "'Cause I shot Cecil." When asked if he knew what had happened to Cecil afterwards, he paused. "He went to sleep?" he said. The room fell silent. Even the prosecutor lowered his eyes. The judge instructed the jury to weigh not only the act but the intent. To convict a child of murder, they would have to believe he understood what killing meant. After just 2 days of testimony, the case went to the jury. 12 men, miners, shopkeepers and farmers, filed into a side room with the weight of an impossible choice on their shoulders. Hours passed by. Reporters smoked on the courthouse steps. Inside, Carl's parents sat, hand in hand, not speaking. When the jury returned, the clerk read the verdict aloud. The jury decided not on murder. They couldn't bring themselves to say the word. But not innocent either. They believed a life had been taken and someone had to answer for it. So, a boy of just 6 years of age was convicted of manslaughter. The judge thanked the jury, then turned to the small boy who sat watching him. He announced the sentence. 15 years in reform school. Gasps filled the courtroom. A woman fainted near the back, and Carl's mother began to sob. He was 6 years old. If he served the full sentence, he would be 21 when released. As the courtroom emptied, one reporter noted the image that would stay with them for the rest of their life. The boy who'd just been sentenced to 15 years, swinging his legs beneath the table and asking, "Can I go home now?" The prosecutor shook hands with the defense attorney. Both looked haunted. Even the judge appeared shaken. The law had spoken, but no one in that room seemed to believe justice had truly been served. Carl was taken from the courthouse quietly, escorted by a deputy who took him to a waiting car. As they drove away, the last thing the crowd saw was a small hand pressed against the glass. A child leaving a courthouse, heading not home, but toward a reform school cell. When the gavel fell in that Kentucky courtroom, the story should have ended, but for 6-year-old Carl Newton Mahan, it was only the beginning. He was too small to understand the words 15 years in reform school. When the judge spoke them, he simply turned to his mother and whispered, "Can I go home now?" That night, Carl was taken to a state-run reform institution near Greendale, Kentucky, a facility built for teenage offenders, not small children. The guards had no idea what to do with him. There were no special quarters, no teachers trained in child development, no recognition that he was, quite literally, still a baby in every way that mattered except in the eyes of the law. The other inmates were older, boys of the age of 13, 15, 17, sent there for theft, assaults and fighting. Carl was half their size. He couldn't read or write. He still spoke with the lisp of a child learning his words. For the first few weeks he cried often, asking for his mother. The guards said he had nightmares and sometimes woke screaming, calling for Cecil. The reform school was meant to rehabilitate, but by the 1920s standards that often meant punishment and hard labour. Carl was assigned to basic chores, sweeping floors, scrubbing pots, folding laundry. He was given simple lessons during the day, learning his letters from a teacher who didn't quite know how to speak to someone so young. He wasn't violent, he didn't act out. Most accounts describe him as quiet, obedient and withdrawn. A boy who had no concept of what he was there for. Letters from his parents arrived irregularly. Sometimes months would pass between them. They couldn't afford the long trip to visit. Carl's father was still in the mines, working to support the rest of the family. His mother's health declined. In every sense, Carl was alone. But outside those walls, his story was taking on a life of its own. Newspapers would continue to follow the case long after the verdict. Editorials questioned whether the court had failed not only Carl but common sense itself. Child welfare advocates, a growing movement in the early 1930s, used his case as evidence that America needed to rethink how it treated young offenders. Letters flooded the governor's office. Church groups sent petitions. Even some of the jurors who convicted him later said they hoped he'd be released. An editorial from late 1929 read, "If a 6-year-old child can be found guilty of manslaughter, then perhaps the real guilt lies not in the boy, but in the world that raised him." The more people learned about Carl's upbringing, the poverty, the exposure to violence, the easy access to firearms, the more they saw him not as a monster, but as a symptom of a broken system. Despite the pressure, Carl remained in reform school for 5 years. Officials quietly began reducing his restrictions as he got older. By the age of 9, he attended basic schooling and was allowed to work in the gardens. He grew stronger, taller, and more reserved. The wide-eyed boy from the newspapers replaced by a quiet, serious child who spoke little of his past. In 1934, the governor signed his release. There was no ceremony, no photographs, no headlines. One record simply noted, "Carl Mahan, aged 11, discharged. Good behaviour." He returned home to a family that barely recognised him. His mother later told a local reporter that he hardly spoke for months, as if the habit of silence from the institution had followed him home. After his release, Carl disappeared from public record. The Great Depression deepened in Kentucky. Small mining towns were hit hard. Families moved frequently in search of work, often changing names to escape the stigma attached to their past. Researchers decades later found little traces of Carl's adult life. Some reports claim he moved north, working in factories or on farms. Others suggest he stayed in Kentucky, living quietly under a different surname. What is certain is that he never again appeared in any criminal or public court record. He seemed determined to live unseen, to grow into a man without the shadow of being the boy who killed. Unofficial accounts suggest he lived an ordinary life and died in the 1990s. An old man who had spent his childhood inside an institution for an act committed before he even lost his baby teeth. But even that remains uncertain. Carl Mahan, once a headline across America, faded into anonymity. Though his name disappeared, his story didn't. Legal scholars and child advocates continued to cite his case in the decades that followed. It became a benchmark in the debate over the age of criminal responsibility. The question of when a person can truly understand right and wrong. By the 1940s and 50s, most US states had introduced minimum age limits for prosecution, often setting the threshold at 7 or older. Kentucky eventually reformed its juvenile code as well, recognizing that very young children could not form criminal intent in the same way as adults. Carl's case was later referenced in law journals as a turning point born from tragedy. It forced lawmakers to confront the uncomfortable truth that poverty and violence were as much on trial as the boy himself. Today, psychologists and legal experts still debate those same questions. How young is too young to punish? Where does accountability end and empathy begin? And what responsibility does society bear when a child commits a violent act using tools that adults have left within reach? The image that stayed with those who witnessed the trial never faded. That tiny figure sitting in an oversized courtroom chair playing with a toy while his future was debated by adults. He couldn't spell the word guilty. He couldn't read the Bible verse the preacher quoted over his friend's grave. He only knew that he wanted to go home. America looked at that image in 1929 and had to decide. Was Carl Newton Mahan a murderer or a child failed by his world? History doesn't give a clear answer, but it does leave us with a question that still lingers nearly a century later. What does justice mean when the person standing on trial can't even reach the floor with his feet? Crime at Bedtime is a Mashed Pumpkin production. Created, hosted and produced by Jack Lawrence. Audio and sound design by Jack Lawrence of Mashed Pumpkin Productions and Dom Evans and James Costa of ESA.